Okay, kansooke okulamusaako gwe wenna ampuliriza. Oba ndaba wano ku Uganda atalaaje mu mikwesese nga bulijjo. Muganda wange, ennaku z'omwezi zaabadde nnya lunaku lwabadde lwakubiri, butereevu mu palamenti, omuliro ate ne General. Muganda wange olwo ajja kulwasimula bugolo. Anti munnange yabadde oli alina okubeera nga ayanukula maaso ku maaso ababaka ba palamenti ku nsonga enzibu ennyo. Jjukira ensonga enzibu ennyo ng'eyo ey'okunnyonnyola ng'ali mu makkati awo. Omanyi waliwo omuntu omwe yagambye nti ate ne General musajja wattu ali awo mu kattu, naye kyalina okukola alina okubeera munnayuganda atuukiridde, alowooze ku kitiibwa kye okusinga okubeera ng'akozesebwa, kubanga Ssemujjunganda juuzi yagamba nti Museveni aleetera abantu abagunjufu bwe bwali badde olabanga abagezi abalabufu okufaanagana ng'abasiru, kwegamba okukola ebintu eby'ekisiru ebireetera abantu okubeera nga bagamba gundi n'akola bw'ati n'anokolayo omu yagamba nti yakozesa kiduma kubuya. Muganda wange omusajja abantu ne bagamba ti laba arizonize ng'akaana ka Nassale. Kakati Kirewa Kiwanuka angabe nkutegeezezza nti munnange bw'atyo yagasimbaganye n'ababaka ba palamenti, okuli leader of opposition Ssennyonyi, okuli Sseggona, okuli Ssemujjunganda, ng'alina okubeera nga ayanukula. Era obutambi mbulina wano obwa vidiyo nga buli omu amukwasaganya mu ngeri era nga naye nga ayanukula mpola mpola, ng'ayanukula ne batuuka n'okubeera nga bamubuuza n'ebyamuhoozi nti naye lwaki towa muhoozi ku magezi n'omuadivisinga ku mukutu gwo gwa X n'ebyateekako. Kakati yabadde omubaka nga sinaba kubeera nga nkuwa obutambi obwo ngenda kuba mbukuwa kamu ku kamu gumiikirizaako obyewulirireko nga basajja muganda wange ate ne General bamuli bubi. Yabadde mubaka Odul yabuuziza ekibuuzo ng'akibuuza ate ne General Kiwanuka nti naye advise oba ebigambo by'otubuulidde wano bye bimu bye wakozesa nga owa Museveni amagezi oba nga advise ng'omuwabula, by'otubuulidde wano bye bimu? Muganda wange munnange Erut South Member of Parliament Jonathan Odul yamubuuzizza era nga yabuuzizza ate ne General Kiwanuka. Odul kwegamba kuyasinzidde okubeera nga amubuuza ekibuuzo ekyo, yamugambye nti kuba twawulirako General Museveni nga akuutinga olunaku olwasookera ddala okwogera, omundi ogwasookera ddala okwogera ku ebyo ebyasaliddwawo kooti enkulu ku misango gya court martial ne ba civilians, nti General Museveni yatugamba nti yakukubira essimu era nga okusinziira ku bye yayogera nga mumaze okugerezanya ku ssimu kirabikanga bye wamugamba ebitamaakinga oba ebitakwatagana na bino ate by'otubuulidde wano, birabikanga ebitakwatagana. Naye muganda bwe nga bwe nkutegeezezza nti abasajja ate ne General nga bamuli bubi nnyo obutakulwisa, ndowooza kansooke nkuwe obutambi buno tusooke n'ani.
Mr. Speaker, I move this motion and I want to thank you. Under Rule 59B, 1B. And the motion, Mr. Speaker, is a motion of adjournment to discuss an urgent matter of public importance. So, Speaker, and I want to thank you. You are generous in allowing us to make comments the way we did about the Supreme Court judgment. But because of the importance of this judgment, I am moving this motion, Mr. Speaker, to persuade you to adjourn the subject matter under consideration and to allow us at least an hour to discuss this matter. Why? The defeat in court was not a defeat just of the Attorney General. In fact, when Parliament was making this law, the Honorable Kiwanuka was not even the Attorney General. So this judgment also touches on how Parliament conducts business here. How you are advised, because the way the Chief Justice described setting up of the court martial, he said it's like asking him to go to Mulago to begin operating patients. That's what Parliament did, and any MP worth the name must take this as a very serious matter. That what Parliament did in setting up the General Court Martial was like telling a lawyer to go to Mulago to operate patients. And second, Mr. Speaker, the constitutional order in the country, this judgment touches on the constitutional order. That you have a military that has taken over management of society. The CDF is issuing one tweet after another. We are now asking Attorney General to advise him. So the motion, Mr. Speaker, of adjournment is to allow us to present these matters to the satisfaction of the public. The public now is very happy with the judiciary. It is time for the public to also be very happy with the Parliament, especially because it's this Parliament that established that General Court Martial. I am lucky I was not in that Parliament. Otherwise, the words of the Chief Justice.
Honorable.
So that's the motion, Mr. Speaker, that I am moving to adjourn consideration of the matters on the floor now to discuss a matter of urgent public importance, and that's the judgment of the Supreme Court.
Thank you. Thank you, Honorable Semuju. No, wait, I guide before. I need to guide. Okay? That's why I'm here. Now.
Thank you, Mr. Speaker. Mr. Speaker, first, I think as the Shadow Minister for Justice, I would like to convey words of acknowledgement and appreciation to the justices of the Supreme Court for coming out very clearly and boldly in delivering this judgment, which had caused great concern amongst the public and some sorts of anxiety. So I would like to thank the judiciary, the Chief Justice, and the justices who delivered this unanimous decision. Mr. Speaker, Article 126, Clause 2E, and I would like to read, says that substantive justice shall be administered without undue regard to technicalities. The learned Attorney General understands this very well. What he is trying to do is trying to delay substantive justice. The orders are clear, and that court martial, in my understanding, has not been disbanded. What I'd expected today or yesterday was for the court martial to sit and say, we are now discharging all these persons that were before us, that at that time we thought we had the authority to try them. But now that court has declared, we are now discharging them. And that would be the most logical step to do. We also know that courts rely on departments and agencies and authorities of government to function. Courts do not have the force to go and pick people, just like the speaker you observed here. As Parliament, we cannot go to prisons and open those padlocks. Courts rely on the goodwill of the executive in implementing the decisions that they issue. So I expected that the Attorney General, the DPP, the Commissioner General of Prisons, whoever is involved, to comply with this. The last point I would like to ask the Attorney General. You have read to us very good advice you have rendered. I would like to know whether you rendered that advice to the President. The President quoted you, that he called you on phone, and you seem to have given him an advice that does not match with what you are telling us here, would you now? And Mr. Speaker, this letter from the president is in the open. I don't need to go through it. But he quoted that he got in touch with the Attorney General, who explained to him certain things. I understand that the Attorney General, being a party to the suit at that time in the heat of the moment, having lost that big case, you would have lost a little bit of your composure. But would you now clarify to us? And I've ever been to the Supreme Court as a litigant, and I lost a case. I know what it feels like. So I understand what the Attorney General went through. But would the Attorney General tell us clearly if this advice that he has told us here is exactly what he rendered to the head of the state? Because what the president wrote potentially undermines the rule of law, undermines democracy, and I thought that it is incumbent upon the Attorney General to guide the president on the next course of action. Would you clarify to us and even lay, where possible, that opinion? Because this is not just advice. You said a legal opinion, and there is clarity on how a legal opinion is rendered. Would we see that here, Mr. Speaker?
Thank you, colleagues in the public gallery this afternoon. We have students from Hatumbanja Child and Youth Development Center, Namayingo South County, Namayingo District. They are represented in Parliament by Honorable Wanyama Mike Odori and Honorable Makoa Margaret. They've come to observe proceedings of this House. Please join me in welcoming them. The Honorable Attorney General. Narrate the Attorney General, please. Answer some questions.
Thank you very much, Right Honorable Speaker.
I can pick another set, okay?
Thank you very much, Right Honorable Speaker. First of all, the court-martial cannot sit. So it cannot sit to make any orders that you want them to make. That's one. Number two, if there are facts that you have, Honorable Medard Segona, as a senior lawyer, if there are facts like you have stated here, the best place to take them is to the court. Yeah? Yes. Secondly, Right Honorable Speaker and Honorable colleagues, Honorable Segona should know that as a practicing advocate, after you are successful in court, you extract a decree. If you think my advice is inconsistent with what the judgment said, you should at liberty to extract a decree, have the court sign it, and use it in the premises that you would like to use it. I have read this judgment variously, and you may think that I was sleeping. I did not. I spent time reading this judgment page by page, and I word for word. And what I have advised here, I did not get from my head. I got from the judgment. The matter under discussion is not the Court of Appeal decision. The matter under discussion is the Supreme Court decision. Was appealed against is misplaced. Now, there are no timelines. I agree. But we have sent the matters to the courts which granted these orders. The courts are still clothed with the authority to make any orders that they deem appropriate. Like
point of order.
You see, Right Honorable Speaker, when the Attorney General speaks, he is the head of the bar. Everybody at the bar ordinarily should keep quiet. I agree with him that a successful litigant goes ahead together with the losing litigant to sign a decree, to prepare a decree jointly. If he was waiting for a decree, what was the basis of his advice? Number two, I am not aware, and he can now educate us, the law under which a losing or vanquished litigant would write to court to ask for which orders. The orders, Honorable Nwagaba says, is self-executing. Is the Attorney General therefore in order to mislead both the House and the country that the person who was in court when the judgment was being issued is waiting for a decree extracted by one party?
Attorney General, you want to make some clarification, if I can guide?
Right Honorable Speaker, I think where we are going here is a bit of a runaround, because I have told you my understanding of the judgment. And yes, and that's why maybe I lost. But what we are saying is that if you disagree with
Hillside View Apartments kyekifo ekitegekeddwa obulungi eri gwe wenna eyandyetaaze okubaako w'opangisa okusula okumala ennaku engere. Ekifo kino kirimu buli kimu, oba oyinza okugamba kiri fully furnished, kirina free wifi, parking nga ziddala ate nga ya bwereere. Apartments zino zizimbiddwa ku mulembe, anti munnange bw'ogipangisa obeera ng'ali mu makaago, tolina kiweetaaga kwetikka kutwala, oyagala kwefumbira, buli kimu mwekiri, ate nga ne ba caretakers babaawo okuweereza. Security y'amaanyi emisana n'ekiro, kifo kisirifu ekiyinza okuwa emirembe okuwummuliramu ate nga n'omulirwano gwa buvunaanyizibwa. Hillside View Apartments zisangibwa ku kyalo Janyi ku Kyaki. Bw'ono munnange ava ku Entebbe Airport ovugirawo eddakiika 25 zokka olubootuuka ekitende Kajjansi, n'ovugirawo eddakiika 8 zokka okutuuka ku Hillside View Apartments. Bw'oba ova Kampala ovugirawo eddakiika 25 zokka, ate gwe munnange ava e Munyonyo Kinyana Mpindi kubanga eddakiika 10 zokka. Emiwendo gikkirizika ate nga gyakuteesa. Kuba ku 0704 13 19 99 oba 0770 71 887 98.
Just we were beginning.
So, Speaker, I want to thank you very much. The Attorney General has said the court martial cannot sit because of this judgment. For the court martial, they are not waiting for a decree. There are also no discussion with anyone else, but they immediately stopped functioning, and I want to thank him. For release of prisoners, including Dr. Wesigi, who is in Ruzira now illegally, because there is no detention warrant. There, the DPP is realizing I have written to Supreme Court. Why didn't you render the same advice to the court martial that continue working as I liaise with the Supreme Court? Why do you think for them they needed to stop functioning immediately, but the others can continue disobeying? I am sympathetic to him. Maybe the same reason that court said military people cannot purport to be dispensing justice. Because the people were asking the Attorney General to advise, they have already expressed themselves. The CDF said Wesigi can only get out of prison in a coffin. Really, what sort of advice can you give a person who thinks like that? Even if you are a professor of law times 3. The CDF, one of the supervisors of the General Court Martial, has said Dr. Wesigi can only get out of prison in a coffin. He had even arranged to kill him. He had even identified a tree in Guru. And that's why I sympathize with you. Sometimes, sometimes these jobs, sometimes these jobs, I think we may need one time. The late Professor Chidomakuya was asked to offer advice to the president, and he said in law you may or may give no advice. That's how he used to talk. In this case, I choose to give no advice. That's what he told the president. One of the reasons he was eventually sacked. Really, what advice do you give to a person who has made the statements that the CDF has made? And then the president who went to Luwero to fight, killing people because he wanted the power. Yes, in Luwero they were not hunting, they were killing. He even speaks about it, how he was robbing guns from barracks, from Kabamba to Masindi to Hoima. He writes trouble is that you support him but you don't read his book, because if you did, all this information is there. He went to Luwero to kill, he killed, robbed the banks, including one in Kabale, and then he said he was fighting point number one of NRM is democracy. And he says judges don't rule. So who rules Uganda? The president and his son. That what they say is sacrosanct. Even the Attorney General, you are wasting your time. So when the Attorney General tells me, understand whether you can render an advice to 2 military men who have already Mr. Speaker, the Constitution does not allow Parliament to take any decision whose effect will alter a judgment of court. In advising these military people who are not listening, the Attorney General said he was talking about an amendment. Can he tell us? And I listened to Honorable Fox Odoi very carefully, and I want to thank him. He said there's nothing to amend. But the Attorney General says they have advised him to amend. So what are you advising them to amend, sir? Thank you very much, Mr. Speaker.
Honorable Speaker, firstly, I'm glad that the Attorney General has correctly advised the Executive to implement the court order. That's a good thing. However, I think that the learned Attorney General is misadvising the General Court Martial. The insinuation in the remarks of the Attorney General is that Court Martial keep holding on to these people until the DPP determines whether or not to take over this matter. I think that that's ultra-vires. Because for all of these people who are being held, Dr. Kiza Besigye, Obed Lutale, NUP political prisoners that have been held for over 4 years now, the Supreme Court said all those matters under the court martial should cease with immediacy. Now, Article 120 of our country's constitution, which provides for the office of the DPP, when you go all the way to number 6 under Article 120, it says that in the exercise of their authority, the DPP shall not be under the control or manipulation of anybody. So nobody is meant to give any order or directive to the DPP. What the learned Attorney General seems to be saying is that now the court martial is going to be directing the DPP to say, we have these matters, you take them up. That's against the law. What's meant to happen, Right Honorable Speaker, is that the court martial is meant to issue with immediacy release orders for these people, because the court martial no longer has any authority over these people. Completely release them, and then the DPP, in her choosing and in her investigations, if she determines that maybe there is any matter that's meant to come before the civilian courts, that can happen. But you see, the two courts are disjointed. Honorable, there is some information, if you'll allow, from...
in just a second, Right Honorable Leader of the Opposition, they have actually, from the communication of the Attorney General, they have actually already interfered with the independence of the DPP by telling her to go and liaise. So it is not that the DPP is not under control. They have already controlled her by telling her to go and liaise with the court martial.
Honorable, in my remaining 1 minute, I would like to cede ground to our Shadow Attorney General.
Thank you, Right Honorable Rope, and thank you, Council Segona and the Attorney General. Mr. Speaker, sir, this particular judgment falls in the category of what we call self-executing judgments. It's a judgment that should be complied with without any other process as alluded to by the Attorney General. Actually, if I were the Commissioner of Prisons, I would have released all those individuals mentioned in the judgment, including the UPDF officers undergoing trials in the General Court Martial in respect of offenses tried by civil courts. And then, as you normally do, you would arrest the people outside the prisons, take them to police, detain them for 48 hours, charge those you can, make fictitious charges against those you can, and do the like. But I think, yeah, otherwise, other than that, what is happening, right, Honorable Speaker, and the Attorney General agrees, is that all players, especially the prison warders who are detaining these people, are doing so illegally. We are literally doing so in the utter disregard of the constitutional provision. So we have overthrown the Constitution. But be that as it may, Mr. Speaker, my worry is in what is actually being planned by the government. Because the information we've got is that they are now trying to come up with a bill to overturn the Supreme Court judgment. And that is the reason why the Attorney General has advised a series of procedures to be taken, which he himself knows are inherently illegal.
Rob, do you want to say anything about it? I've not yet opened debate on the report. I'm only bringing a matter of the law on where the limit of our powers stops.
Honorable Speaker, the legislature is the third arm of government, and the executive is accountable to this legislature. And that's why when we raised these matters, when I specifically raised this matter, is because ultimately the people of Uganda have recourse here in the legislature through their legislators. The report is saying EC should consider extending the period of the voter verification exercise. We are not sitting here and directing and saying, EC, you should extend this period by 30 days. If you don't, we are going to do A, B, C, D, E. That's not what we are doing. We are saying, EC, based on all these challenges, which they also admit, because they have also admitted to, number one, their kits are not adequate, because you find one kit where you're lucky per sub-county, where you're unlucky, 3 sub-counties are using one kit. Some of these kits are defective. The voter education exercise has not been adequate because LC1 chairpersons who are part and parcel of this process, many of them are just getting to know now. So the Electoral Commission is conceding that there have been challenges, and that's why we are saying it should consider extending, because it is their duty. They are the ones that came up with this roadmap. They are the ones that can extend. So we are playing an advisory role for their good as well, because they come to Parliament saying, now give us money for this exercise, give us money for this other exercise.
Just Honorable John, I totally agree with. I just want you to take me on the matter of the law. I'm a presiding officer of the House. I want to preside over the House lawfully. Okay? So, issues of justification, what it's very, very simple. Can we interfere with? Yeah, it's here. Because when you go for one recommendation, for example, I have here recommendations where we are directing EC on what to do. I have the EC should review the demarcation of electoral areas. Okay? I have EC should EC should engage investigative agencies to investigate and prosecute who, yes, I brought it to you. Otherwise, I would have ruled. But I want us to be within our limits in as far as the law is concerned. Okay.
Maybe finally, right, Honorable Speaker, I actually agree with you because previously I was raising the concern of the DPP not being directed. But you see, the Electoral Commission falls under a certain sectoral committee, even for accountability purposes, vis-a-vis how are they utilizing the resources given to them. and accountability committees. Number two, are they executing their mandate within the law? So I think it is okay for Parliament to say, by the way, your mandate as the Electoral Commission is to follow this law. In demarcation and that kind of thing, please follow the law. I think that's within our powers as Parliament to call to order any entity in this country, because it is our oversight role.
Thank you. Honorable Mpuga.
Thank you, Right Honourable Speaker. Right Honourable Speaker, I must first of all state that I'm a member of the Committee on Legal and Parliamentary Affairs. And therefore, in enumerating the issues before the House, we had in mind the limitations of our duty. And there's a reason why the EC appeared together with the UBOS and the NIRA. Synchronizing their role is part of accountability. And if you go by the command of Article 63, particularly 5, sub-article 5, on the roles of the Electoral Commission, barely 10 months the elections, and they have not done that role, and the abdicative, outlook of UBOS in releasing the census results, this Parliament is really doing its work in reminding them of that application and reminding them of the timelines